To be honest, I'm still confused about what she is trying to say because she keeps starting ideas but never finishes them. So far, I've heard different claims, including that she was assaulted, that she has chlamydia, that there was a baby shower organized for her, and that she walks like a model. She also mentioned being threatened with a Polaroid of her son in order to force her into committing crimes she says she did not do. I truly don't understand what is going on here. It is very unclear and hard to follow.
Ms. Young wanted to go down a line of questioning related to some previous experiences that she has claimed, specifically, I think, a form of assault, maybe references to a lack of therapy. And my ruling was that I had not seen any reason or relevance of that. Those sound like arguments of mitigation of why perhaps you're not as culpable as as the state might allege, that you should receive a lesser sentence if you're guilty of these offenses. But the issues here for the jury to determine are the issues of fact, of whether you did in fact commit any of these offenses. And I haven't seen how a previous sexual assault or a lack of therapy essentially bears on determinations of this at all. But if you want to further argue that or be heard on it, now's an opportunity for you.
When I first hired Leaf Howard as my lawyer, he was told of the instance multiple times. I'm not sure as to why you all didn't get it. I was not familiar at the time of the court's process and who I needed to reach out to. I let him do his job, but it was not to my recollection that they did not know of what happened to me. But yes, there was a night that I went door. Are you asking me to?
No, I don't really. I'm trying to stay big picture, which is what is the reason why the jury needs to hear about this?
Well, I don't know who the person was that came after me. Not only did they come after me, but they had a Polaroid picture of me carrying my son to my friend's house. It had a blue blanket, had me with my black outfit on, and I had on a headscarf that I always wear outside. When I saw that picture in the midst of what was happening to me, not only on the day that Captain Winfrey, I don't know if she's still captain, but at the time, she threw me a baby shower. Even when I first started working there, I was called out by, I believe, Captain Winfrey. Captain
Winfrey is who we just heard from.
No, that was Grady.
Oh, I'm sorry. Excuse me. That was
okay. So yes,
Lieutenant Grady.
It's been a minute. I'm trying to remember names, but she threw me a baby shower at the jail. And when I first started walking there, I was called out for the way that I walked. I walked like I'm a model or twitching my butt or something. And that put me on the spot for everybody in 6 North. So there is no way for me to know if it was because of the baby shower, because she invited my mother and father without my knowledge too. And if I had any knowledge that she would do that, I would not have invited my parents there, because I keep my work separate from my family for this reason. My son was in danger, I was in danger, and there was a instance that happened in the car. But I got
I'll be honest with you.
From that,
I'm still not sure what.
Okay. The judge is allowing her to proceed with asking these unusual and very unclear questions. However, there is a major issue in all of this. She doesn't even seem to know who she is referring to or talking about. Her line of questioning is confusing, disorganized, and lacks clear direction. It becomes difficult for anyone in the courtroom to follow her point because she is not identifying the subject properly or explaining things clearly. This makes the entire exchange even more difficult to understand in a legal setting.
To break this down, is it your claim that someone from an inmate in the jail or another employee there
that may have
did this sexual assault?
That may have been the one to do. I don't know who the person was.
Where did it occur?
I tried calling DoorDash to get in contact to see if I can get it, because I called customer service. I parked my car, but I didn't lock my doors. I was having issues with the internet.
Let me rephrase. Did this incident happen inside the jail or outside the jail?
Outside the jail, okay. But I was working with Fulton County at the time.
All right, so the objection came, you were asking Lieutenant Grady whether he had some awareness of a baby shower and that sort of thing. Mm-hmm. Do you have any reason to believe that he did?
Because if he's aware of the baby shower...
Oh, no, that's not my question. Not if he is. Do you have any reason to believe that he was aware of the baby shower or your sexual assault?
I would think he does know about the baby shower because they're all connected. They're always talking, having meetings and whatnot. And it was a surprise to me. So it's like, how else would you get my personal information if you maybe talk to my supervisor, maybe talk to my captain? We've had issues in the past as well. Nothing detrimental, but I still need to know where it could have came from. Anybody. It could have came from Captain Winfrey. It could have came from Lieutenant Grady. It could have came from the inmate.
What could have come from them?
If my family was invited to the jailhouse, they could have been followed back. Someone could have been like, here's her information. Because with that situation, me being touched, I was forced to bring whatever they wanted into the jail because they have a picture of my son. Who knows if the next picture might be him at his daycare or me coming into my house. My father.
Okay, I understand. So any position of the state, I mean, I'm just trying to focus on process procedure here.
Right.
The things that Ms. Young is saying, I think that if she chooses to testify, she can go into them.
I agree, Your Honor, but I think at this point, I don't think there's sufficient basis for her to ask witnesses regarding some type of baby shower. I'm just not clear as to the nexus or the sequence of the events that would make it relevant at this particular point in the trial.
Okay. I agree with you there. What we're focused on is, I mean, at this point, I don't think it would be, maybe this additional, I think you said lieutenant that's coming may have knowledge of this potentially that she could ask about.
That is the person who threw the baby shower initially.
The person who's coming next?
Yes.
Okay, well, glad we're talking about it now then. All right, well, I think then you can ask this next witness some of these issues. You're going to have to be careful with your phrasing. I think the state's objection to facts, not evidence, is one that could very well come again.
She brings up the familiar claim that it was not her signature, trying to challenge the document on that basis. However, in the same statement, she also acknowledges that she signed an oath of office, which directly contradicts her defense. This creates a clear inconsistency in her argument and raises questions about credibility. It will be interesting to see how this contradiction is addressed moving forward in the proceedings. Overall, the contradiction weakens the reliability of her statement. The issue remains significant.
It's not the person that was, wrong name.
All right, just for the record, Mr. Miller, can you summarize what exhibits are on the stack that are going to the jury?
Yes, Your Honor. What will be going back to the jury will be State's Exhibit 1, which is the oath. State's Exhibits 3 through 9, which are photographs outside of the jail, as well as the posting. State's Exhibit 12, which is the evidence log. State's Exhibits 22, which is the caduceus report, and State's Exhibits 23, 24, and 25, which are the GBI lab test results.
Everything else is going to be held back?
Yes, Your Honor.
All right. I'm going to place the redacted indictment, Court's Exhibit 1, and the verdict form, Court's Exhibit 3 on top of that. And then when we have the consolidated charge as Court's Exhibit 4, we'll include that in the stack. And that will be ready to go back to them when we complete the charge.
And Your Honor, may I place a copy of the oath?
If you've already got it, just make sure you show Ms. Young that before you do so. I mean, it's a bit redundant since it's also Exhibit 1, but all right. So based on what was just said on the record, is there any objection on behalf of the defense as to what would be going back in the jury room during deliberations?
I would say the oath of office. I object to it because that signature, I have to look over my own document again. My signature, if I'm not mistaken, I signed something else. I'm sorry, let me rephrase that. That typed signature, I'm going to have to look at my document and make sure it matches because I'm not sure, I'm not too quite sure if that matches what I actually signed when I...
At this point, the proceedings pause as the judge announces a 15-minute recess, with the court set to resume at 1:50 for closing arguments. This detail is important because it establishes the timeline for what comes next. When the session reconvenes, however, the situation changes unexpectedly. Only one party returns to the courtroom while the other is absent. This creates a noticeable disruption in the process and immediately shifts the direction of how the closing stage unfolds.
To the authenticity of this document and whether it should be considered by the jury. That ship sailed when it was admitted and there was no objection. So those being the only grounds, then your objection is overruled and Exhibit 1 would be going back. Any other objections?
No objections.
All right. So we're holding in place until we have the consolidated version. That's going to take maybe a few more minutes. Are the parties requesting some additional time to prepare for closings?
Your Honor, state's ready.
I just need a brief bathroom break.
Of course. Do you need a PowerPoint or anything else like that?
I do, Your Honor. So what I would do is I would just take my laptop, if I can, with me to the podium, and I'll just conduct it that way.
You're doing the closing?
Yes, Your Honor.
Okay. And you're opening and closing?
Yes, I'm going to do the close. So defense can go first, and I'll do everything at one time.
All right. So the state's planning to reserve their first closing. And so what that means, Ms. Young, is you'd be up first when we come in and begin closing arguments.
Okay.
And so we'll just take 15, prepare what you need to, practice your PowerPoint, and just let the jury know about 15 minutes we'll be ready to go. We'll be in recess.
Thank you.
At this stage, the jury is brought back into the courtroom and the prosecution proceeds to present its closing arguments on its own. The defense side is not actively participating at this moment. Although the defendant does eventually return, it happens too late, as the jury has already been excused and sent off to begin their deliberations. But this timing leaves the closing phase heavily one-sided and shapes the final part of the trial in a very unusual way.
2:05, it's about 15 minutes past when I instructed the parties to be back at 1:50 to begin closing arguments. The state is present, the defendant is not. I've asked our deputies to search the floor. They have not found the defendant. They've also sent someone into the bathrooms. She is not in any of those. And we are also now trying to make a phone call. The only phone number we have is to her mother, who had previously conveyed a message for us Monday morning to have her here to start trial. And at this point, we're also going to review security footage to see if she walked out of the front door of the courthouse. But looking at her table, it looks like all of the papers and things that she came with are not here anymore. She left a jacket behind. But otherwise, all of her belongings are no longer here, from what I can tell. And we're now well after the time I told her to come back. She has not been spotted anywhere on this floor. And so I believe that she has now waived her appearance going forward through this trial, and we can proceed even in her absence under our case law. I would instruct the deputies at any point, if she shows up, she should be let in, and she can resume being here. But until she does reappear, we're just going to proceed. So, Mr. Miller, are you still ready for closing arguments?
It is not the court's duty to ensure a party returns on time. The judge clearly instructed to be back at 1:50, yet the defendant did not return until around 4 p.m. Because of this delay, the court began to question whether the defendant would complete the trial properly or might avoid further proceedings. As a result, a bench warrant was issued and she was taken into custody for the remainder of the trial to ensure the process could continue without disruption.
Your Honor, Ms. Boykin just went to the office, but she's on her way back now.
Okay. Well, I think we can go ahead and just put some things on the record that we need.
I need paperwork out my bag, if that's possible.
Okay, one second. Okay.
All right, let's go back on the record. And first, I would like to perfect some information we received while we've been here on break during deliberations, which is that I requested Lieutenant Lattimore to review surveillance footage to try and help us locate Miss Young, and he was able to see some footage. And so I'd like Lieutenant Lattimore to share with us for the record what he was able to view and what he observed, and then we'll go from there. So you could just describe that for me, Lieutenant Lattimore?
Yes, Your Honor. I was able to review footage of Ms. Young exiting the 136 checkpoint at approximately 1:51. And from the checkpoint, she proceeded down Pryor Street, which is south of us, and made a left at Mitchell and Pryor, and proceeded east on Mitchell up to Washington Street, where we observed her make a right turn. And at that point is when we lost sight of her movement.
And this is all through surveillance footage you're reviewing after the fact?
Yes, Your Honor.
And that's several blocks away from the courthouse. All right. Miss Young, where were you going?
Before I answer that, I previously stated that you were in contempt of justice, because of failure or refusal to proceed in equity under exclusive jurisdiction. Did you not acknowledge that we were in equity jurisdiction?
If there's anything else you want to say, Miss Young, this is your opportunity to have it on the record. But I'm really not interested in getting into a back and forth. So if you had some kind of emergency come up or something else you needed to address, that's what I was kind of curious about. But otherwise, we're going to move on.
I did. I needed something to eat. I haven't really eaten since last night. I'm pregnant and I felt like I was about to pass out a little bit. I did kind of forget what time we had to come back. But I got a call from my mother stating that I was supposed to be back in an hour. So that was what took me so long, because I went to grab something to eat and I was going to come back. But after I got that call, I was like, okay, well, he did extend the time. But there was miscommunication there. So I apologize for that, Your Honor.
All right, so I just want to break that down, which is it's now about 4:30, and I think they found you trying to re-enter the courthouse about 20 minutes ago or so closer to 4 o'clock. And so you believe that you got a call from your mother saying you didn't have to be back for an hour, and I think we called around 2 o'clock because we were trying to start closing arguments, as I'd indicated.
If I can look at my phone records, she called me and told me that I didn't have to be back until an hour because the court, whoever called her. And I've updated my phone number, email address in the Odyssey system, so I'm not seeing why
And at this point, her arguments begin to reflect typical sovereign citizen reasoning. For clarity, courts operate with different types of jurisdiction. A criminal jurisdiction deals with offenses that can lead to fines or imprisonment. Civil jurisdiction handles disputes involving monetary compensation. Equity jurisdiction focuses on non-monetary remedies, such as court orders preventing certain actions like construction on disputed property. This helps explain how courts...
We've put your explanation on the record. You can, and so that's all well and good. However, I've lost confidence that we can expect you to appear on time for court proceedings, so I've revoked your bond, I've issued a bench warrant, and so you will be in custody pending the outcome of this trial. More to the present business at hand. No, it's not your turn, Ms. Young.
Oh, okay.
I do have Court's Exhibit 5, which I've marked and will tender for the record, which is a question from the jury. It states, and is available for inspection for the parties once I'm done reading it into the record, is there any statutory minimum for possession of a Schedule 1, Schedule 2, or Schedule 4, respectively, where intent to distribute is presumed if you are in possession in excess of such amount? And it's signed by the foreperson. And so if either party would like to, if the state would like to see it, you can come up and grab it. And if Ms. Young would like to see it, deputies can take it to her.
This is a question from all jurors or specifically?
It's from the jury.
Okay. And though you're failing or refusing to proceed in equity under exclusive jurisdiction, you acknowledge that on the record as well?
All right. My proposed response to this would be
you can't
no.
deny that injustice.
And that I would just write on the note, no, and that we would refer them to their previous instructions. Technically, there is a presumed amount, but that's for trafficking, and that's not been charged in this indictment. They asked specifically about the intent to distribute, whether that's ever presumed based on the amount. As I understand it, it is not. So I think it would be an accurate statement of law to say no, and then just refer them to their previous charges. Any input? First from the state.
So they say a minimum. Are they referencing a minimum sentence? An amount?
I take the question as a whole. It's a statutory minimum where intent to distribute is presumed. So I know we use minimum in reference to sentences, and that was my first impression as well. But reading it as a whole, it seems to be focused on the evidence of distribution and whether that intent can be presumed based on a minimum amount of drugs. And again, that's where I say the answer to that legally is no. Or actually, I mean, it really just says intent to distribute means intent to unlawfully deliver or sell. So maybe the actual relevant charge would be intent generally, which can be shown in many ways, whether it existed from the proven facts before you. It may be inferred by the proven circumstances or by acts and conduct. So actually, maybe what I would do is say no and then just reread the intent charge and then say that they should place no undue emphasis on this charge and only consider it in the context of the charge as a whole.
State agrees, Young.
All right. Any input from Ms. Young?
Yes. So you are not acknowledging the fact that you're in contempt of justice on the record?
She kept insisting on hearing from her so-called fee schedule, but the judge made it clear that such a point cannot be considered when the courtroom is constantly interrupted and the process is not followed properly. After repeated warnings and findings of contempt, the trial moved forward. Eventually, the jury completed their deliberations and returned with a decision, ready to present their verdict in court. The process then moved to formal announcement, where the outcome would be read in open court following standard legal procedure. All parties waited for the final decision to be delivered.
Your failure or refusal to proceed in equity, being that you acknowledge the equity jurisdiction, exclusive jurisdiction, will constitute in contempt of justice. I've tried to show you as respondent to all complaints and questions because of the legal special relationship that I have paid on this account. I was about to go and e-file it into the system. Are you in contempt of justice? Are you recontracting?
Are you done?
No, I'm not. Are you recontracting the trust?
You remember what I told you at the outset of this trial, which is that if we started getting into it, you started interrupting me. All right, Ms. Young, I'm going to find you in contempt of court, and I'm immediately imposing a 20-day sentence, no matter what happens as a result of this trial. And I'm directing you not to interrupt me any further. All right?
You asked me a question, but you didn't answer it.
I'm finding you in contempt a second time, Miss Young. That is an additional 20-day sentence I am imposing.
You can do as you please, because at the end of the day, you have no jurisdiction. You are in contempt of justice,
Please, if you could
and you cannot
escort Miss Young
refuse.
from the courtroom.
Come on,
I find her
yeah.
as
You'll be hearing my
disrupting our
fee schedule. Let me
proceedings.
put this up.
I got that.
And you know you're in contempt of justice. It's okay. You'll be here.
The prosecution is recommending sentencing of 3 charges with 15-year terms, of which 10 years would be served in custody, while 2 additional charges carry 5-year terms to run at the same time as the main sentence. In total, this amounts to roughly 10 years to serve, followed by 5 years of probation. While that already sounds like a very serious punishment, the actual outcome that follows turns out to be even more severe than what was initially expected,